In this episode, we will be discussing the District of Columbia Landlord Tenant Laws. The following is a summary of landlord tenant laws in the District of Columbia as they apply to residential rental property. Topics include disclosures, withholding rent, the right to enter, security deposits, eviction and termination, rent control, and more. Required disclosures. At the start of every new tenancy, landlords are supposed to give tenants a copy of the District of Columbia Municipal Regulations, Title 14 Housing, Chapter 3, under the heading Landlord and Tenant, and a copy of Title 14 Housing, Chapter 1, Section 101, under the heading Civil Enforcement Policy, and Chapter 1, Section 106, under the heading Notification of Tenants Concerning Violations. Security Deposit Limit. Except for rent-stabilized units, a security deposit may not exceed the amount of 1 month's rent. Also, the lease or a receipt must state the terms and conditions under which the security deposit was collected. Deadline for returning a security deposit. After the tenant vacates, the deposit must be returned within 45 days, along with an itemized statement of deductions that were made. Security deposit interest. Interest at the prevailing savings account rate must be paid when tenancy ends. Late fees. Late fees must be addressed in writing. They cannot be charged until after the 5th day the rent is due, and cannot exceed 5% of the rent that is due. Landlords also cannot 1. Charge interest on a late fee, 2. Assess multiple late fees on the same payment, 3. Evict solely because a late fee wasn't paid, or 4. Impose a late fee for the portion of rent that a subsidy provider, not the tenant, is responsible for paying the landlord. Rent control. There is no rent control for a landlord as long as he or she owns no more than 4 units in DC and operates as an individual as opposed to a corporation. Unless the rent amount is bound by the terms of an existing rental agreement, a 30-day notice must be given prior to increasing rent. For larger landlords, the Rental Housing Act of 1985 governs all multi-unit apartment buildings and housing accommodations. Under this law, annual increases are allowed with a 30-day notice and must be based on the increase in the Consumer Price Index, known as the CPI. A lower cap must be followed for elderly and disabled residents. Larger increases may be requested from local authorities if significant improvements were made. Withholding rent. If a landlord is notified of a problem with a rental that affects the habitability or health and safety of the occupants and fails to fix the issue in a timely manner, rent may be withheld or repairs can be made by the tenant and reasonably deducted based upon receipts. However, this process should first begin by documenting the unit by requesting an inspection from the DC Department of Consumer and Regulatory Affairs. Terminating tenancy and eviction. If a court determines that an illegal act was performed within the rental unit by the tenant or guest, the landlord may serve the tenant with an unconditional 30-day notice to quit. For all other lease violations, a 30-day notice to cure or quit must be used in order to give ample time for the tenant to correct any issues. The right to enter. DC laws do not specifically address the right to enter. However, tenants cannot unreasonably keep a landlord from entering for maintaining or showing the unit. As a courtesy, landlords should give 24 hours notice for routine business. No notice is required if the tenant requests maintenance, and landlords should feel confident about entering in the case of an emergency. For more information, additional laws and articles can be found at American Landlord, landlordtenantlawsclub.com.